thank you for the great talk. We're going to start right off. Can you please define for us what is intellectual property?
Hi, George. Thank you very much for having us. It was a pleasure talking to everyone. The crowd was great, very knowledgeable, and the questions really provoked us. So intellectual property in general, it's any creation of the human mind, whether it's literary or artistic work, that can be commercialized and or utilized by an individual or a company.
And what are the different types of intellectual property that you can encounter?
There are many different types of intellectual property. They range from trademarks to patents, copyrights, industrial designs, and domain names. Any entrepreneur or a startup at the beginning phases, they should think of a copyright, a trademark, and a patent.
Okay.
And actually, it should be in the reverse order. Patent, trademark, then copyright.
Right. And can you expand a little bit on the differences and how they work?
Okay. For tech entrepreneurs, what we're finding is they have a software that is by default copyrighted, but they might have an inventive step in the method of analyzing the information provided.
Okay.
And that's when they should think of a method patent. Why not a copyright? Because with a method patent, it's much easier to commercialize it and sub-license it.
Okay. So what exactly is it, a method patent?
A method patent is a patent, so it has the non-obviousness, usefulness, and novelty. And it has an additional step or a step that is different than any step that is usually done. The additional step or the different step cannot be obvious to an average consumer. It has to be something that you came up with, be it in the algorithm, be it in how we're analyzing the data that we get. It's very specific to the entrepreneur. What I would advise any entrepreneur who has a software, before they publish the software, to approach a lawyer and ask them specifically about method patents.
So really think about the way you're doing things before you actually apply for a patent.
Right.
So applying for a patent can be a bit of a technical thing. If I'd like to see just simply what exists on the market, what patents are already there, so I can differentiate myself from them, I don't necessarily have the means to hire a lawyer or an IP firm for that. So how can I get started? Where can I go with this?
Initially, just start with a desktop search. Go on Google, there are Google patents, go on the US Patent Office. All patents are published, unless they are still in the examination phase.
Right.
If they are in the examination phase, no one will be able to find them. But once they are accepted and granted, they are published.
Okay.
So any entrepreneur can research and do the prior art search themselves.
Right. So every country has a sort of a centralized pool of all the patents existent.
Right.
Okay. All right. And how long is the patent valid for?
A patent is usually valid for 20 years.
Right.
That's the legal rights. Nowadays, the commercial right of a patent is becoming much shorter because of the tech industry is moving very quickly at this point in time, so it's very rapid growth. So we're finding that entrepreneurs have a 5 to 7 year period to commercialize their patents and not more. The moment you file it non-provisionally, you're protected. If it's a solid patent, you can start using it, especially if it's tech.
Right, but still, I guess this should still be consulted about with a lawyer.
Definitely, definitely. And a lot of IP lawyers work with startups on a pro bono basis.
Okay.
At least for the start. Everyone wants to invest in startups, so talk to a lawyer. If they're not willing to help, reach out to someone who's willing to work with startups and get advice. You have to have the proper advice. And please do not publish anything. Because we have a lot of entrepreneurs who had patents, but were not able to utilize them or register them because they had published them. Someone wrote an article about them, and they lost the right to patent it.
Okay, so the second there is public exposure before filing?
Right. I lose the novel step.
Okay.
Okay?
Right. So as an entrepreneur who has a new idea, I can't obviously patent the idea itself. What are the steps I should take before going to the patent office? What do I come and give them as documents?
So before you go to the patent office and before you decide on whether you patent or do not patent, do a simple search. Check if there are other patents that exist or not. are they similar or identical to my idea? If they're identical to my idea, then I cannot register the patent. So after you do your research, you figure out that it's not registered, and so you can register it. The first thing you do is start drafting the idea.
Okay.
The patent is divided into different parts, so you have the abstract, you have the claims, you have the description, you have the drawings, and so on. You will not know about these, but start writing the idea, transfer it from your mind to papers, and go and sit with a lawyer who has experience in patents, specifically in the industry you're working on. After you draft the patent, we file it at the trademark office or patent office, and they examine it. The patent is published. If it's granted, the patent is published, and then I get a certificate.